Decision podcasts by the New York Prosecutors Training Institute are made possible by VoicePods. Convert your text to voice at voicepods.com. Read this decision at NYPTI Law. www.nypti.org/law.
People v. José Guevara, decided on September 9, 2021. Memorandum. The order of the Appellate Division should be reversed and a new trial ordered. Defendant José Guevara was convicted by jury verdict of one count of manslaughter in the first degree, Penal Law Section 125.20. After defendant provided timely notice that he intended to present psychiatric evidence at trial, he was twice interviewed by a clinical psychologist engaged by the people. See CPL 250.10.2.3. Although defense counsel was present at the first examination, the expert denied defense counsel admittance to the second examination. Over defense counsel's objection that defendant's right to counsel had been violated, the expert's testimony was admitted at trial. On defendant's appeal, the Appellate Division affirmed, holding that defendant's constitutional right to counsel had been violated but that the error was harmless. We now reverse because we conclude that the error was not harmless. In matter of Lee v. County Court of Erie County, we held that defendant's Sixth Amendment right to counsel applies at pre-trial psychiatric examinations, to make more effective, a defendant's basic right of cross-examination. We thus held that pre-trial psychiatric examinations are a critical stage of the prosecution. As the Appellate Division recognized, our decision in Lee controls here. To determine whether the error requires a new trial, we assess the error under the harmless error standard that applies to violations of constitutional rights, People v. Crimmins. The people, not the defendant, bear the burden of showing that there was no reasonable possibility that the trial court's admission of that part of the expert's testimony based on the uncounseled examination affected the jury's verdict, People v. Ellis. See People v. Sheffer. Under the circumstances of this case, the expert's testimony at trial was based in part on the examination undertaken in violation of defendant's constitutional right to counsel, and we cannot say that the error was harmless. See People v. Cherami. Defendant's argument seeking suppression of statements he made to the police is without merit. In light of our reversal, we need not reach the defendant's remaining arguments. On review of submissions pursuant to Section 500.11 of the Rules, order reversed and a new trial ordered, in a memorandum. Chief Judge DiFiore and Judges Rivera, Fahy, Garcia, Wilson, Singas and Canatero concur. Decided September 9, 2021.
Decision podcasts by the New York Prosecutors Training Institute are made possible by VoicePods. Convert your text to voice at voicepods.com. Read this decision at NYPTI Law. www.nypti.org/law.